Colleagues in the media may be aware of the fact that on the 20th of March, Mr. Speaker adjourned the House sine die. At the time the House was adjourned sine die, there were 3 items of urgent importance to government that had been advertised to be taken. They were advertised on the order paper of the day. And these were the items. 1, the adoption of the 34th report of the Appointment Committee on His Excellency the President's nomination for appointment as ministers, regional ministers, and deputy ministers. 2, motion on additional financing agreement between Government of Ghana and the IDA for an amount of $150 million to finance the ongoing Greater Accra Resilient and Integrated Development Project, also known as the GARID. 3, request for tax exemption for selected beneficiaries under the 1D1F program. On the first item, you all know that Mr. President did some reshuffle and came out with some nominations. As you are well aware, the appointment committee sat on all of the nominees, interviewed them, engaged them, asked the relevant questions, and the report, as was tabled on the floor, was by consensus. So all we left to do is to take it through the motion of voting. On the issue of the GARID, that is the IDA 150 million, the committee had done its work. In fact, we had taken the motion, and the Works and Housing Subcommittee, Committee of Parliament had expressed certain views, and Mr. Speaker advised that the matter be taken back to committee and the leadership of the Works and Housing Committee be asked to join to express their views so that said views get incorporated. In fact, this was done, and all that is left is for this item to be taken so that government can access this concessional facility to show up our forex. We all know the situation with our city, and these are things that if we are unable to speedily deal with, would affect our economy. In the financial sector, it's a speculative sector. And if these things are not managed well and we allow things to remain in the limbo, it affects the government and the country. Whether or not the Majority Caucus is invoking its rights under the law in good faith, my answer is yes, we are. As far back as the 8th of April, I, on behalf of colleagues, sent a memo to Mr. Speaker. In that memo, my humble prayer to Mr. Speaker was for him to exercise discretion under the powers given him in orders 53, 57, and 58. Unfortunately, my prayer was not successful. So we took the first major step. We are left with no option than to invoke our right under Article 1123. For the avoidance of doubt, Article 1123 of the Constitution provides, notwithstanding any other provision of this article, 15% of members of Parliament may request a meeting of Parliament, and the Speaker shall, mandatory shall, within 7 days after the receipt of the request, summon Parliament. Now, this constitutional imperative has found space in our new rules book, the rules book of the House, that is the standing orders, Order 53. So, Order 53 is also repeating, as it were, the provisions in the Constitution. And again, I shall proceed to read 53, 1 and 2 together. 53, 1, quote, despite any other provision, 15% of the members of Parliament may request a meeting of Parliament, and the Speaker shall, within 7 days after the receipt of the request, summon Parliament. 2. Parliament shall convene within 7 days after the issuance of the notice of summons. So we are fortified by law to proceed with our prayer. Therefore, in terms of these, we have initiated the process to trigger this, and we do so, like I said, in good faith and for the good of our democracy. We understand that our colleagues have their own views. Our colleagues in the minority have their own views. We can't take those views away from them. After all, we are not the same. We are two political parties competing for power. They have their ideological views, we have ours. In any event, again, for emphasis, we have a Supreme Court precedent where the Supreme Court held that even where it is a state institution, to the extent that the state institution has its own independent board, and such board gives approval, it cannot be construed to mean that the mere fact that it is a state institution, it is a matter which government is directly involved. So it must fall under 181. I repeat, in Dr. Mark Esebe-Yeboah case, and in fact I did that very case, and if you recall, we had sued the government of Ghana on the matter of car power, where the argument was to the effect that car power had a transaction with ECG, and the Minister of Finance, Honorable Setekwe at the time, had written directing GMPC to issue a residual guarantee to back the transaction. Our contention was to the effect that government was electing ECG and GMPC at its alter ego. Therefore, the real elephant in the room was government. And our argument was to the effect that government had failed in its duties to the people of Ghana to bring the agreement to Parliament. Now, we lost the case. I was counsel for Dr. Esebe-Yeboah, and it was a 7-0 unanimous decision. The Supreme Court said, no, yes, you may be right, but don't forget that there is an enactment, which enactment has created an independent status for that state institution. So if that state institution, through its board, is able to take certain decisions in spite of the involvement of government, you cannot argue an alter ego here. Neither can you say that because government is involved in one way or the other, the matter must come to Parliament under Article 181. By parity of reasoning, even if we want to argue that the transaction comes under the ambit of Section 33, the issue again is that GRA, being an independent organ of state with its own board, in view of what the Supreme Court has said, should GRA bring its transactions to Parliament for parliamentary approval, because such transactions have a multi-year value. So we are of the view that what government has done so far, urging GRA to review and ensure greater transparency in a transaction with SML, is in the best interest of Ghanaians, and it confirms this government's commitment to ensuring transparency in governance and doing away with unnecessary suspicion. And to me, that is all that is required. Not many governments will be bold to take such risk, especially when it's an election year. It tells you that Mr. President and members of his government have nothing to hide. Now, finally, on this matter, we, the Majority Caucus, have also become aware of a call for a release of the KPMG report in full. May I refer to the Right to Information Act, Act 989, and specifically rely on Section 5 of the said law, which said law is subtitled Exempt Information. Information for the President or the Vice President. And quotes 5.1. Information is exempt from disclosure where the information is prepared for submission or has been submitted to the President or Vice President for consideration. Or B, contains matters the disclosure of which will reveal information concerning opinion, advice, deliberation, recommendation, minute, or consultation made or given to the President or the Vice President, and is likely to undermine the deliberative process on the part of the President or the Vice President, or prejudice national security. I'm not going to the second leg, which is prejudice national security. That's not our interest. Our emphasis is on 5.1bi, which for emphasis I read, undermine the deliberative process on the part of the President or the Vice President. Now, in this case, it is the President. There's no doubt on our minds that the document is for advisory purpose. It's an opinion, which opinion is guiding Mr. President in decision making. So it is not within the rights of anybody to demand, much as it is written in law that public documents for the sake of transparency and good governance be released to the public, and members of the public have a right to receive these. It is also a written bona fide of the President on this occasion to keep this advice opinion to himself. In any event, when you go to an auditing firm to get such advice, it is also conditioned on the fact that you will need their written consent to reproduce such document to the public. So the President has given a summary of what he has received. He's still in the process of engaging the state institution and is guiding the process to ensure the greater good of all of us. And I'm sure that his press statement and the letter where he talks about the good sides of the report and even the adverse findings should tell you how government is committed to ensuring transparency. So again, we commend Mr. President, and we also commend Manasseh and the work he's doing. I mean, if as politicians or as government, We don't have a very strong civil society. We don't have a strong media to keep us to our toes and point out issues, however trivial they may be to us. Governance will not be for the benefit of the people. I'm told that Ghana's ranking in the media space has really gone up today, which is good. So we encourage them to continue with their work, whilst government also takes steps to address concerns as and when they come.